Paul McConnell from the Dr. Lawyer team. I'm going to talk to you for a moment about how we go about deciding what amount to put in for a claim for medical malpractice when we submit it to the Department of Veterans Affairs. That is on the form SF-95. There's a block at the bottom, 12B and 12D, which requires us to allege a certain amount or demand a certain amount for each case. It's important. It needs to be a sum certain or a whole dollar amount. And I reference that because in many lawsuits around the country, whether it's in state court or federal court, you only need to allege or claim that it's more than $15,000. It could be a $20 million case. You only need to allege that it's more than $15,000. But under the Federal Tort Claims Act, it has to be a sum certain or whole dollar amount. So then the question is, well, how much? It's very much an art form to that, and it's certainly case by case, but one of the important factors to consider is that whatever amount goes on that form, it cannot be increased later if you bring in a lawsuit later. So don't request an amount we're not going to request because we want to settle it at we think we can settle a case for $500,000, but if not, we're going to go to trial and ask for $2 million, then we need to ask for $2 million now. There's also art involved because at this stage, we don't know everything about the case. There's been no discovery and the like, so it's hard to value a case sometimes with not having all the information. So we err on the side of caution and give us room in case more information develops that would make the case worth more than we assess it to be worth now. So err on the side of caution. At the same time, you don't want to go too far because then it just seems completely unreasonable for the torts branch when they're looking at it, or even the Department of Justice in the case of a civilian suit later. If it's a case that's realistically a $500,000 to $1 million, or even $2 million case, then we have to keep the allegations in that area, not $20 million. We've had some people come to us, we've seen from time to time, we didn't accept the case, but they submitted their own SF-95 form for X, Y, and Z, and they wanted $90 million. That would probably be a record, and their case wasn't worth that, and it's just easy to dismiss. So there's an art involved, and hopefully this helps answer